We're here talking to Tom Newkirk at the Washington, D.C. office of Jenner & Block, April 5th, 2019. This is an oral history for the SEC Historical Society. We're talking about Tom's long career at the SEC. And Tom, thank you for the interview.
Well, thank you, Harwell, for coming here. I really look forward to our conversation.
Thanks so much. We like to start asking our participants about their background. So where did you go to college and law school, and why did you choose to go to law school?
I was in Cornell. I was a junior there in the liberal arts school. I was sort of bored. I took some psych tests, and they determined that I would be a good accountant or a good lawyer. So as a lark, I took the LSAT tests and did well. And there I was as a junior, and Cornell had a program where you could combine your senior years and both in an undergrad and as a first year of law school. So as a complete lark, I said, okay, I'll go to law school next year, and if they'll let me in, and they did, and see how I like it, and I loved it, and that's where it all started.
So you came out of Cornell fairly young.
Yes.
So while you were at, I should ask how you got interested in securities laws. Was there something at Cornell that particularly interested you?
I was always interested in business and the business side of it, and I had a good professor at Cornell, Dave Ratner, whose name will come up later in our conversation again, and I had a securities course with him, and I thought that it had a lot of interesting intellectual content in it, and I seemed to get it. And so when I went to Donovan Leisure out of law school, I did securities work there, securities and securities litigation primarily, in the time I spent there, and that's how that happened.
And how long were you at Donovan Leisure?
I was there about 5.5 years.
And
I was there twice. I was there about 5 years in New York, and then I was in the Washington office for 2 years after I'd spent some time working for the Congress on the securities industry study.
So what did then, you were in New York at Donovan Leisure, and what led you to Washington?
I saw that sometime in the fall of 1971, I think it was, that the Senate had authorized creating something called the Securities Industry Study to look at the back office failures that took place in the late 60s that almost took Wall Street down. And I saw that my professor, Dave Ratner, was going to be the chief counsel for the Special Securities Study. So I called him up and said, this sounds interesting. Can I come down and work for you? And he called back to me a couple of weeks later and he said, no. There's one of those senators has got somebody who they want to place on the staff. I haven't got a space for you. And then I think in January of 1972, he called me back completely out of the blue, and he said, I managed to get rid of that guy who was put on my staff, and I said, I've got space for you now, can you come down? And I think a week later I was down here in Washington and for the securities industry study, and that's how it got started.
And very quickly, why was that? Was it a good time to take a break from Donovan? Did you want to try something else?
I'd been doing it for 5 years. I was interested in the subject. I thought the world of Dave Ratner, and thought that working for him for a 10-month study couldn't hurt my career, and plus it would be a lot of fun. And I think both of them probably turned out to be true.
What did you actually do? What was the security study actually? You said it was looking at Wall Street after the back office crisis. What did your work on it actually involve?
My responsibility was to work on the issues of the application of the antitrust laws to the securities industry and to the fixed commission rates that were in place at that time. And as you know, the fruit of the work done on the fixed income rates eventually ended up with Mayday and the elimination of fixed securities transaction fees. But so those were my two areas of focus. There was one other thing I was responsible for too, and frankly I can't remember what it was.
So we can credit you with the loss of the fixed
No, I think that belongs to Dave Ratner. I mean, one of the things we did at the time was, while we were at the commission, while we were there, there was an attempt to raise the commission rates, and Dave sent a bunch of letters to, I think it was Bill Casey then was the chairman, a bunch of letters raising questions about, well, if we're going to a regulatory industry pricing model, you know, just like the electric companies or the other utilities do. There's a basis for what they're charging, and it's built up from the bottom. And so send me all the stuff that you've done to build up that builds this up. And of course, there were no such things. It was purely numbers negotiated among the big players. And I think Dave did a good job really torturing the SEC about the approval of the rate increases, and that and lots of other things that were in place, they were unsustainable. There was a whole bunch of secondary markets developed to compete with the NYSE, to attack the fixed rates. So I don't think we can claim credit for that. We contributed to it, but it was really the economics eventually destroyed the fixed commission rates.
Okay, and I know you didn't head to the SEC for a number of years after that, but being in Washington at this time, was this your first significant exposure to the SEC directly, or what sort of interactions did you have?
That was really my first time I had any real serious connections with the SEC, other than being, one of the junior associates, working on either litigated issues or on filings.
What was your impression of them at that time, in the early 70s?
Hardworking, aggressive people, smart, and believed in what they were doing.
So you said you spent 10 months on the Senate committee?
Turned out to be about 12, actually.
Okay. What after that?
By that time, my wife had moved down. She's a lawyer also. She'd gotten a job that she liked. Donovan and Alicia said, well, if you want to come back to us, come back to New York. I said, that's not going to work. So they put me in the Washington office for an indeterminate time, but the deal was that eventually I'd have to go back to New York if I wanted to stay with the firm. After 2 years, they said, come back. My wife said, have a nice time. So I eventually ended up at the Office of Legal Counsel working for, at the time, Nino Scalia. Which was just a great experience. Wonderful man, wonderful boss. So I was at the Office of Legal Counsel, and there eventually I got involved in the creation of the Department of Energy, and the people I met in the course of doing that led me to work to move to the Department of Energy, first as Assistant General Counsel and then as Deputy General Counsel, and I stayed there for a total, I think, of almost 7 years.
So it's an interesting, I don't think it's a common path to go from the Department of Energy back to the SEC. So I wonder if you could talk a little about what led to that transition.
Well, one of the things that we did at the two things about the Department of Energy that were of interest. One was building something new when I got there was really great, very challenging, very rewarding. But the other thing we were doing, and the main thing that it did that people were aware of, was the fact that we were responsible for the price controls on oil and gas, primarily oil. And eventually it was deregulated, so there was a lot of tail-end work to do with respect to the litigation arising out of it, but it had become not a valuable skill set to have. Plus the place had become sort of old government. It was huge. And I decided I needed to do something else to get retooled, to improve my different skill sets so that I have more options. And as a result, I started applying for jobs at the SEC. And I applied three times for what are now SO positions, at the time were SES positions. The first one, Bill McLucas got the first position that I applied for. The second one was Phil Parker as the chief counsel, and eventually I met a third time with Gary Lynch about the chief litigation counsel position, and Gary took a huge chance on me, and I'm appreciative for it ever since.
So I want to hear in a minute, obviously, about your career at the SEC, but can you compare because you mentioned the DOE had become sort of old government, can you compare the working life or what your experience was in, say, a very large bureaucracy, like you said, I believe the Department of Energy had become, as opposed to the SEC, which was certainly smaller at the time you joined it?
It was. I mean, the Department of Energy was huge. My group was huge. Hundreds of lawyers in my group. It started off being sort of like the people on the price control were sort of like people at the SEC. They believed in the mission. It was new. It was in the news. It was demanding intellectually. The pricing regulations were extraordinarily complicated, very difficult to master. So that was fun. I'm not sure it's good for the economy, but it was fun to do. But it morphed into being old government. There wasn't the sense of drive that you saw every day. When I went to the SEC, people who were driven to believed in what they were doing, worked hard, very smart, very collegial, quite a small group. It was more comfortable. I found it was a very comfortable place to work.
If I can ask as an aside for a question, so by the time you joined at the SEC, you would have been 50, 40 years old. Have you ever wondered how the SEC managed to maintain, sort of not fall into the rut you described at the other agencies?
I don't know whether it was my thought at the time or thinking about it subsequently, but I think one of the keys was that it didn't have anything to give away to people in the sense of agencies that are really licensing people and could give out bennies of one sort or another, whether they be television licenses or other things. And as a result, I think that I'm not a great believer in the regulatory capture model, but there's some of it. But at the SEC, there wasn't any, I didn't think there was any of that, and I still think there isn't any of that. That the securities industry certainly can be heard at the SEC, but I don't think that it ever became captured by the SEC.
Okay. So you joined the SEC in 1985 as Chief Litigation Counsel.
Right.
And heading up the trial unit. And I guess as to introduce this, can you talk a little about what the trial unit actually did within the larger enforcement division?
The model in the Home Office was that there were the investigative groups that did the investigations, and then if there was going to be litigation, it was handed over to the trial unit. And at the time I went there, I think there were 8 or 9 or 10 people in the trial unit. But the trial unit people weren't much involved in the course of the investigation.
Okay.
And there was a tension between the investigative people and the trial unit people. The trial unit people thought that the investigative people didn't do thorough enough investigations, and the people in the investigation group thought that the trial unit people, were afraid to try cases, and some of the tension is natural. Mm-hmm. No litigator ever saw too little evidence. But at the same time, that there was this tension there, and it wasn't a happy situation. And I think one of the things that Gary wanted me to do was to try and find a way to reduce the unhealthy tension between the people on the investigative side and the trial unit people.
And what did you do then to try to overcome
that? I think with Gary's support, there was more integration of the work. People in the trial unit were brought into cases earlier, before the decisions were made, so that they could contribute in terms of seeing how you'd see the evidence as a trial unit person as opposed to as an investigative person. And I think it gave rise to its own tensions, but I think by and large that it worked better for everybody involved, and I think that's something that's been continued.
Okay, to expand on that, how did you approach your role as a supervisor? That is, I assume you didn't do a lot of litigation if you were actually running the unit. We can talk about.
Yeah, my dream was to do litigation, but it didn't work out that way. I was probably naive in believing that I could do that. By encouraging people to be respectful of the people you're dealing with, to understand it from their point of view as to what they were trying to do. And I got a lot of help from the associate directors and from Gary to tell people, we're going to do this. and people did it.
Was there a sense, so you joined in 1985, which it seems to be just about the time a lot of stuff was really getting started with, obviously, the Drexel and the Milken matters. Was there a sense that there was a need to beef up the trial unit? Did they want to raise its profile, or was it just that happened to be a position that was open for you?
It just was a position that was open. My predecessor had moved on, and they needed a chief litigation counsel, and I was just lucky, so lucky that Gary picked me.
So what was going on in 1985 when you joined? I want to get to the very long
The cases that were there when I first arrived
Yes.
there was, I think, Baldwin United, which was a big accounting case. There were a bunch of cats and dogs. There were, not big cases. Yes, a couple of, I can't remember the name of the firm, but there was a fairly large firm that basically ended up putting out of business, and deservedly so. The first Jersey case had just been, I think it had been filed in 1984, and it was developed in what was then the Washington regional office, and it was taken into the home office. And that went on for close to 10 years. I mean, that was a big case. People who watched TV at the time, you could see Brennan with his helicopter, making pitches for the junk that he sold to investors. A lot of IPOs that were just, companies that you never heard of then and you never heard of since. Those were the two, the Baldwin United and the First Jersey cases were the big name cases that were there when I got there. Baldwin United was eventually settled on a satisfactory basis, and eventually, after many years of trench warfare, we won the First Jersey case as well, and as a result of it, of course, he decided that he's going to avoid paying him back the $80 million that we recovered at the time. He did a bogus bankruptcy and subsequently went to jail for bankruptcy fraud. But the thing that the big thing that happened first while I was there was and my first court appearance for the SEC was in, I think, May of 1986, bringing the temporary restraining order against Dennis Levine in the insider trading cases. And as you know, the Dennis Levine case led to all the big cases, big broker-dealer cases that took place from then on through the end of the 80s.
So how did that, can you talk a bit more about that? It's because it seems you walked in the door at the right time.
I walked in the door at the right time. Somebody else had done all the work and basically handed the file over to me and said, go to New York and file this case. I was scared to death.
Why?
I hadn't done a securities case. I'd done some work as an associate in Donovan Leisure, but I hadn't been in a court other than doing pro bono stuff on my own, straight up in a securities case. And it was really a huge deal for the commission. And I was scared, and scared was good. I was really prepared.
So you start out with the Dennis Levine case. Can you talk about sort of how that evolved over the next few years and the other kind of litigation? Because obviously there were criminal cases, there were civil cases, there were...
The criminal case, and he recognized that he was dead in the criminal case, and the coin of the realm in the Department of Justice's cooperation, and he eventually gave us Boesky. And Boesky, he had something to give too. He had Milken to give, and Boesky had a bunch of other people to give as well, but who were tipping him on deals basically, and that's how the Milken case developed. They all developed out of the Levine case, and that's what we did lots of people at the staff did for years after the Levine case.
So Milken is especially notable for fighting the charges for a long period, at least for a while. Yeah. What was it? How did you handle that litigation? Dealing with him, obviously he had a lot of resources for a lot of very talented lawyers.
So this was before electronic document review and all that stuff, so we had a warehouse full of documents. And the question was, how are we going to get through this stuff even though all the people who worked on the investigation were carried over and worked on the litigation, and pretty much at least half of the trial unit were working on the Milken Drexel case, but we needed more ammo, and the FDIC had brought a case against Drexel arising because of the banking losses that had occurred, also as the FDIC claimed, because of the misconduct that had occurred at Drexel and involved the same core document and information. And the FDIC had hired Cravath to do the litigation for them. So I thought, well, this is a good opportunity to leverage on their thing. So even though there's a provision in the securities laws that lets the SEC keep anybody who wants to be consolidated with the SEC case, the SEC had the power to consent to let other people participate in an SEC case. And I thought, well, why don't we call the people at Cravath and see if they want to work with us on this case? And if they do, we'll consent to it, and we'll leverage up on their resources. And that's what we did, and it worked out really well.
Has anyone done that since?
I don't believe anybody's done it since, but I'm not aware of any of the staff having done that since then.
So that actually, let me ask a question at least relating to that, or perhaps connected to it. You said there were 8 attorneys in the trial unit when you joined.
Right, 8 or 9, yeah.
8 or 9, which seems to be a number that would be dwarfed by the litigation division of any large law firm. So in other ways, how did you deal with, or what ways did you try to leverage when you, now I won't say outgunned, but clearly the other side had a lot
outnumbered, not necessarily outgunned.
I think that's better.
We had, I think that's true almost all the time in government.
Yes.
In big cases, you're always outnumbered. It wasn't just the people in the trial unit who worked on the cases. The people who worked on the investigations, or at least some of the people who worked on the investigation, would be brought either willingly or unwillingly into the trial unit to work on the litigation. So, plus we had the advantage, I think, of having worked on it. I mean, the people on the investigation had worked on it for a number of years, and they really knew the case, so that the lack of asymmetry in resources really wasn't that big a problem, because we'd already been through the documents and had that stuff. So it wasn't. I never really felt we were overwhelmed, except in the Drexel case, and we solved that problem.
Okay. So obviously with Drexel, and frankly with other cases, there were criminal charges as well as civil litigation. Can you talk a little about how you interacted with U.S. attorneys, federal prosecutors, perhaps especially the Southern District, because I know there's a very long-running relationship there.
When I got there was already a very tight relationship between the Home Office and the Southern District, and the New York Regional Office, and the U.S. Attorney's Office in Manhattan. And that continued through the entire time I was there, and I have every reason to believe that it continues today, that it's just a very close, complementary relationship, and I think it's good for investors, it's good for the public. It really is it's a rare example of really close working together without people sticking their elbows in somebody else's face.
Okay. You mentioned the regional offices. How did the trial unit interact with regional offices? Because they obviously had investigative units. Did they have their own trial?
In theory, I was responsible for all of them.
Okay.
Some of the regional offices had their own Chief Litigation Counsel, and had to worked like the Home Office model, where the cases would be handed off. Some of the other offices had and still have a different model, where basically the people who did the investigation are also the people who take the lead in the litigation.
Was there any rivalry there, a desire not to hand off to trial unit?
I think that in the Home Office, where I had a better view of it,
yes,
they were in general glad to have the experienced litigators to pick up the case. probably not universal, but nobody ever said, we want to do this. I'm not aware of anybody going to the director and saying, get rid of those trial units. I don't want them on my case here. I'm going to do it myself. I never saw that happen.
Okay. So I don't know if you want to talk more about what you did in the Drexel matter and with the Levine matter, or there are a couple of other, at least one other matter you worked on while you were at the trial unit that I wanted to ask about, which was Crazy Eddie.
The Crazy Eddie case was a lot of fun. Mm-hmm. He was a great crook, a very clever crook while it lasted. And he made the fraud run much longer. The frauds were quite gross, but he had figured out how to beat the auditors in their audits so that he would go and when the auditors went home at the end of the day, he or his henchmen would break into the auditors' trunks and find out what their plans were for the next period of time, and so that he would structure his business in a way to reduce the likelihood that the auditors would ever figure out what they were doing.
But you eventually...
Eventually. I like to say that all accounting frauds eventually fail. Mm-hmm. Of course, the ones that were never discovered may not have. There may be some out there that haven't failed. There may be some small ones. But if you're running a big scale fraud that depends on continually making your numbers to grow, I don't think it can be done.
So one other thing you might have dealt with when you were at the trial unit, which is when you were hired, or I guess when you departed the SEC, the SEC news release noted that you had also worked a good deal on emergency relief cases to freeze proceeds of insider trading and halt fraud. You mentioned already with Levine you went to get a TRO. So you got a chance to litigate
exactly.
At some point.
That was the only litigation I managed really to do. They were great fun because it would be a defined period of time. I wasn't going to stay on through and work personally on the day-to-day work of the document discovery and all the other stuff that goes on in civil litigation. So that the investigative people would, tell us that because we were doing a better job of being informed as to as trial unit, what was going on, particularly in cases that might break quickly. And so you'd get the case, somebody on the staff side would draft the first complaint, we'd fiddle with it, we'd put together the affidavits, whatever else we needed, and run into court and get a temporary restraining order. And most of them were ex parte, so you had to be very careful about what you said to the judge to be accurate in what you said and not to exaggerate because there was no other side, but you knew they were going to show up, or they may show up. If they were off-seas, sometimes they decided not to show up, okay. Which tells you something, but you had to be prepared that they were going to show up, and you had one of the coins of the realm at the SEC was to have the judges trust you. You didn't get a second chance if you didn't preserve your integrity with the judges, and so it's really important to be to make sure what we said, be careful about what we said, but go to New York, file the case, go see the judge, tell him what you had, and that was usually the end of it. Sometimes we'd go through a preliminary injunction thing. Usually you'd end up with agreeing to some sort of a stay while the case develops. So they were fun. I like doing it.
That's interesting. I hadn't thought that maintaining your reputation with a judge, who obviously you would see again in over the course of much litigation, would be something important for you.
If you want ex parte relief, the judge, if the judge don't trust you, you're not going to get it.
So,
and if you don't, and in the offshore ones, if you don't get the emergency relief, because you're trying to freeze the money here in the U.S., by the time you go through any process at all, the money is going to be gone. Because while you can ask the broker-dealers to keep the money, they're going to say, I can only do it if it's a court order. Otherwise, I'm going to be liable to my customer. So that it was the ability to get ex parte temporary restraining orders for the offshore trading where the traders were offshore, but the money was here, was very important.
Did you do, so you spoke of some of the people working for you at the trial unit. Did you handle hiring there? Did you choose people to come into the trial unit?
I took some people out of the investigator side who wanted to get more trial experience, but I think most of the people came from outside.
Okay. What made someone particularly good at that job?
Very smart, good work ethic, and ability to work and play well with others. Because in the government, it depends on that, not on power.
So you were at the trial unit about 6 years.
Yeah.
Are there any other major cases of litigation or major cases you worked on that come to mind as particularly memorable or even particularly colorful?
Well, I think that Eddie was great. Crazy Eddie was great fun. The Levine through Milken thing was tremendously satisfying.
Mm-hmm. Why satisfying?
Because the conduct was really bad. It did a lot of damage to the economy and to the capital markets. My view was these were people who thought the rules didn't apply to them, and I'm a law and order guy. I think the rules apply to everybody.
Okay. So after 6 years, you became associate director.
That's right.
And can you talk a little about I'll ask two questions. First, why did you wind up deciding you wanted to do something else than heading the trial unit?
Well, I'd done the trial unit for 6 years. I never managed to do what I hoped to do there, which was to try cases myself. So I thought it was time to do something different. One of the associate director positions opened up. And I thought the investigator side, I thought probably would be fun to do for a while and satisfying to do for a while, to put the puzzles together rather than try to hold the puzzles together in the litigation. And it was very rewarding. And it was in the transition between the trial unit and the associate director position. I got involved in the Prudential investigation. I think I got first involved with it when I was head of the trial unit, and then I continued to work on it with the people in the investigative side on the Prudential case, which is the case that I worked on there, of which I think I'm proudest of my time at the SEC.
Let's go ahead and, I'm sorry.
The Prudential case involved Prudential's fraudulent sales of hundreds of billions of dollars. I think it was $8 billion of poorly thought out limited partnerships that they sold to moms and pops for some of it had tax benefits in them, some of them had promises of returns that were never going to happen, and the whole thing collapsed in 89, 90, 91, leaving retail investors with huge losses. And a couple of good things came. I mean, in the Prudential case, we got them to the table fairly quickly. We had the assistant director who was in charge of the day-to-day running of the case was Jerry Eisenberg, who decided we're going to try something different with these people. They put together basically a book of the key evidence, which would have been the core evidence if the case ever went to trial, and invited the people from Prudential to come in and said, here's what we have. Now let's talk turkey because we've got you cold. And when you go through this, you're going to find out we've got you cold. And I think they didn't tell us they agreed, but they did agree to settle the case, and we ended up negotiating a settlement with them that was unique, whereby it was uncapped. Well, they had to pay up a lot of money in front to pay back injured investors. It was uncapped, and they agreed to appoint Pollock as the administrator for the fund with non-reviewable discretion to decide who gets paid and how much they get paid if they wanted to participate in the program. And I think the first shock that he gave the company was when he decided that people are going to get interest on their payments, not just the loss that for investment they made 5 or 6 years ago, but they're going to be paid for the time value of the money that they got. Plus, he was tough on and fair in terms of measuring what people's losses were, and so that it ballooned to well over $1 billion. Drexel was on the hook to pay whatever amount was.
Prudential.
Prudential, I'm sorry.
Yes.
Yes, thank you. It's one of those few cases where investors were really compensated in whole by the SEC.
I was struck by going back and looking at some documents because it's interesting looking at newspaper stories. When Prudential first announced this, they estimated that it would cost them about $300 million. And of course, it wound up, as you said, cost them well over $1 billion. Was it the SEC's thought to get Commissioner Pollack to administer this, or was that something Drexel? I'm sorry, no, I did it. Was that? You're right. Was that something Prudential brought forward?
It may have come from the defense side.
Okay.
And we were tickled pink about it because we knew his integrity and his concern for investors was unmatched. I don't know. I do think that it came from the defense side.
So, apart from the amount, so it sounds as though Prudential really stands out in your memory as a case you're particularly proud of, a matter you're particularly proud of working on. Was it the amount of it? Was it the egregiousness of Prudential's behavior? Because clearly these were horrible investments for retail investors.
Yeah, the product that they sold was bad, and a lot of people bought it, and so a huge number of investors, all the ones who participated in the program, were compensated in full. There just aren't that many SEC cases where that many mom and pops get back their losses due to a securities fraud.
Is it because the typical fraudster would not have the money by the time they got caught?
Well, certainly with the pump and dumps, that's the case. With the large brokerage firms, I think the answer is no company who knows about the Prudential case and all that would ever agree to an open-ended deal like that. I can't imagine that they would. So I think that probably is. So then you have the problem of trying to figure out, well, what the losses really are. And I haven't been involved in haggling like that at the SEC, but I expect that there's a lot of haggling going on, and that they end up being some sort of a compromise as to what the amounts are. I'm not. Only people who are inside making the sausages are going to know what the components really were in it, and I don't.
So I'm curious about something. I happened to learn this about the Prudential matter, but I think it's something that would come up generally concerning people who represented Prudential, because in the book Serpent on the Rock, which is about this case, Gary Lynch was Prudential's lawyer, who in fact was obviously hired you to join the SEC, and you're sort of in a reverse position now in that you must find yourself representing clients against people you might have known while you're still on the staff. What is it like to find yourself on the other sides of the table from people you've worked alongside?
That's fun too. It's you can be friends with people and still be a civil, hard-fighting adversary against them at the same time. That's one of the nice things about law, is that you can do that. That touches a little bit on something else we talked about, I think, was the revolving door, which is that I think people who think there's something wrong with the revolving door have it all wrong, particularly in terms of the SEC, because the people who work at the SEC, I think, leave it with the SEC ethic in them, which doesn't mean they're not going to fight you tooth and nail, but at the same time, that the vast majority of the people who leave the SEC and go into private practice strongly encourage their clients to comply with the law. I'm a true believer in that. I really believe it. I see it every day.
Okay. So I want to back up for a sec. So you become associate director in 1993. I have to ask, what was your role as associate director? Because there are accounts that say you oversaw a lot of cases, but what does that actually day-to-day mean about your involvement and what you were doing?
Well, my joke used to be, was to tell people my job for my people working for me was to get the debris out of their way so that they could do their jobs. And I had really brilliant assistant directors the entire time I was there. I would give them guidance. I'd take a second look at what they're going to do. I'd work with them to formulate plans for either for settlement or litigation or dropping the case, as it may be. So, I mean, one of the beauties of the job was I got to pick what I wanted to work on. But my job really was to be a check on my staff to make sure that they aren't drinking their own Kool-Aid too much, but at the same time to protect them from things that are getting in their way.
Okay. So I want to talk a little about setting priorities and how you chose to pursue certain cases. And I'm aware that, of course, you have, to some extent, your job would have been reactive. You've got to respond to a major case that arises. But still, in conducting interviews, I found out that there are always going to be people doing pump and dump. There's always going to be insider trading. There's always going to be microcap fraud. How did you sort of distribute your resources to manage to cover both those and the giant breaking cases, be it an Enron or whatever?
Well, the job was to, the enforcement division has always tried to maintain its fingers into each of the different types of, or be active in each of the different types of violations that occur, so that people don't think that, well, if I do this type of thing, I can get away with it. And in terms of providing opportunities for my staff, I tried to give them the experience to work on each of the different kinds of cases that they'd have too, because it provides something new for them to do, a new area to explore. And that's how I did it. You get guidance from the chairman, from the commissioners, from the director about, new areas to focus on, or maybe we need to spend more time focusing on this area than that. And so you go looking for cases in that area. But when I was there, it was quite a reactive thing. The joke would be that, particularly when the accounting cases started, that everybody would race to the early edition of the Times and the Journal to see what was going on, because you usually, the default position was the people who found the case got to keep it. Okay. So, I would go make sure I read the newspaper early every morning. I always complained that the people in New York could get the New York Times at 2 o'clock in the morning, get the early edition there, so they had an advantage. But it really was entrepreneurial in that sense. But again, it was reactive to what you learned, what was happening. There wasn't much. I can't think of any cases that I worked on that were significant that were brought to me by a whistleblower, which is different now. I think I think they do get really good whistleblower cases. I don't recall having gotten any at the time I was there. There may have been one or two, but nothing that sticks in my memory.
Was there ever a sense that some cases were things you sort of had to deal with because a big scandal had erupted, whereas in other cases you really wanted to perhaps send a message to, if there was a developing fraud in a new area, or otherwise to sort of make it clear that the SEC was paying attention to a particular issue?
Absolutely. The point was that's the deterrence part of it, to let them know that we're there and we're looking. Okay. I think we started off talking about insider trading stuff. Yes. And one of the things about it is that you seem to see every 10 or 12 years or so, you see a burst of insider trading cases. And I think that's because a lot of the people involved in those cases are relatively young and don't know the history of what happened before. And so it's important for the SEC to bring those periodic insider trading cases to remind people that, the consequences of getting caught are really bad.
Sure. So this might be getting a little ahead of ourselves, but when you think of priorities, when you think of how you decide what you need to pursue, were those decisions that you would have discussions on within the Division of Enforcement? Because as we can also discuss, each chair seems to come into the SEC with a sense that certain issues need to be dealt with some issues they want to pursue. Perhaps I could ask about Chair Levitt and the numbers game, because that seemed to make a splash at the time, but also lead to I won't say if it leads, but it was connected in time with enforcement matters, accounting enforcement matters.
Well, Arthur raised the importance of it, but most of the accounting cases that I worked on grew out of a restatement. Eventually it fell apart. A couple of them didn't develop that way, but most of them developed out of a restatement. You see the company's done a restatement. What's behind it? You know, is it just errors, or are they are they frauds? And for whatever reason, I think in the late 90s, we saw huge accounting cases surfacing, and you have to wonder, what was going on there. There's Sunbeam. We talked about Crazy Eddie.
Yes.
There's Sunbeam, and then there was Waste Management and Ahold, and the ones I worked on, and Sendent, and Tyco, and Time Warner. They were really bad conduct and stuff that was really hard to figure out. How people thought that they were going to keep. When was it going to fall apart? Because each year required more finagling than the year before to keep the balloon up in the air, and eventually they burst. With respect to many of them, some of them we helped burst them.
Did you ever figure out why? Did you ever reach a conclusion about why people would engage in accounting fraud if, as you said, it would snowball and it would something that would inevitably come out?
I don't think they had that realization. I think part of it was driven because the development that had taken place in compensation tied more and more to financial results, and I think that put, I don't want to say pressure because it's not the right word, an inducement to engage, to make the numbers, to get their bonuses, which could be a huge multiple of what their basic salary was because of the way the tax laws work. And I think that happened along with it was a certain failures in the auditing firm. The combination of the consulting business and the auditing business put pressure on the auditors not to be too tough, because the firms were the profitable side of the auditing business wasn't very profitable.
Yes.
The consulting business was fantastically profitable, and so that some of the individual auditors were just corrupt. The others convinced themselves that, well, I just don't need to look at things so hard. It was sort of averting their eyes. It was a serious failure, and it made it possible to let the frauds run for as long as they did. Many of the frauds took place in the corner office, basically, or in the executive committee people, and with top level adjustments. If you look at them carefully, you can see what they were. Some of them were more. I think of Health South as being a more clever one, where basically all the fraud took place in the hundreds of places where they were providing physical therapy. That made it much harder to detect. But it was a failure of the accounting firms, and part of it, I think, maybe was a failure at the SEC too, to have not paid more attention to it at the time.
So I want to talk about some of the particular matters in a minute, but when we discussed this before the interview, you made an interesting comment. You said the accounting fraud cases were fun.
They were fun.
And I wonder what made them fun.
They were fun putting together the puzzle as to how this particular fraud took place, how it was disguised, who the people were who were involved in it. It required, I wasn't the guy who was going through hundreds of thousands of documents. That part was not so fun, but the staff, to its credit, they plowed through. The staff would plow through that stuff, and in many cases it was done, by hand, because electronics weren't used to the same extent that they've become. But once you'd see the pieces and see them falling together, it was just fun.
Was investigating them particularly difficult? For instance, did the lawyers in enforcement need accounting expertise? And I'm also curious because what you just described about Health South makes it sound like an incredibly complicated scheme to put together.
It was an incredibly complicated scheme to put together. Eventually, eventually it fell apart. But I'm sorry, what was the question again?
I was asking how the actual investigations went, if they were, because some, like Health South, must have been very difficult to actually find the particular pieces to put together. How you would supervise or oversee.
Required a lot of work.
Yes.
That wasn't one of my cases.
Okay.
But my belief is eventually there became a cooperating witness who helped put it together.
Okay.
It was complex enough so that you may recall that the district judge in the SEC sought sought preliminary injunction against them, and the district judge in Alabama denied it, which I think didn't reflect well on her very well, but it reflected also on how complex the scheme was there.
So let me actually ask about a few of the particular cases.
Sure.
And one colorful case to start with is Tyco.
Tyco, the most interesting thing about Tyco is what's unusual about it was how it got started.
Okay.
Because this didn't come from a restatement, and it didn't come from an article in the Wall Street Journal that somebody was raising questions about Tyco's accounting. It came to me because I got a call from my friend John Moscow, who was, I think, the deputy district attorney in New York, and he called and he said, I want to come down with Bob Morgenthau and have breakfast with you. I said, sure. He came down and he said, we're doing an investigation of Kozlowski, and it's a tax case based on his avoiding sales taxes on the art he bought that he sent empty boxes to New Hampshire, where there was no sales tax, and hung the art up in his apartment on Fifth Avenue. But in the course of that, issues came up about his misappropriation of funds from the firm and about some of their accounting issues. And he said, we don't have the resources to do this. We need your help. But pretty please, if we're going to bring this case, we'll bring this case to you, but you have to agree not to take this case across to your friends over at the U.S. Attorney's Office, because they'll steal the case from us. And Morgenthau or Moscow said, these guys are going to go to jail and they're going to go to a state penitentiary, and that's a suitable outcome for these people. So would you agree with us? And I agreed. I said, I can't do it myself. I got to go to the director. talked to the director about it. The director said, yeah, have at it. And that's how the case began. But it too was a very complicated case involving stuff that could be, without a red face, described in some cases, some of the issues as being not so clear. And so it took a lot of work to, some of the stuff was, clear. A bribe to a director, for example, is pretty straight up, and I think Jim Walsh ended up pleading to a case, pleading to a felony in state court. But some of it was very hard to put together, and it wasn't concluded. It was wrapped up after I left, but the case was, as we would describe, was in the can at that time, and it was just getting it filed and negotiating the settlement. So that was really a hard case to put together, just because it had a lot of different moving parts in it as well, and which ones were. And we, at that point, the staff were getting tips from people, many of which were plausible, and didn't work out, so that some of them turned out to be very valuable. So that's one of the things that made it hard to pull the case together.
In the sense of you had to work through all the tips.
Had to work through all the tips and not leave something that was important aside, and also putting the core case together as well. There were difficult issues. Some of them issues were difficult.
Okay. What about the Sunbeam case? Chainsaw Al Dunlap had gotten himself, actually perhaps like Kozlowski, had gotten himself a lot of publicity. He was a guy who built this great reputation at Scott, which he was never caught for. And he went and did the same thing at Sunbeam, basically making acquisitions, creating huge reserves in the course of the acquisitions, and then bleeding the reserves back into earnings as time went by to boost the earnings. Those weren't earnings. It was completely bogus. But he'd managed to do it before at Scott and wasn't caught. And at least that's my belief. And he did the same thing at Sunbeam, and he did get caught because it became unmanageable. And to their credit, the auditors did eventually figure it out. But the fight against the company got rid of him. Got a reasonable settlement for the case. The case with him was a fight, and eventually we ended up settling that case too with the help of a mediator, and showing that we were willing to go to, we're prepared to go to trial. Let's call your first witness. Why was it such a fight? Why was
it was in his nature.
Okay.
That's my take on it.
Yes.
And I've subsequently seen that it's really interesting that before he got to Scott, he had done something at a paper company in upstate New York that failed after he left, and that was never discovered by the headhunters who placed him first at Scott and then at Sunbeam, which is really, I just learned that in the course of preparing for this conversation. I didn't, but he had a history before he got to Scott that was not disclosed to the headhunters who placed him. Or at least that's the story I read in preparation.
Okay. So I want to talk about waste management, both because it was an interesting case in itself and because it related, and Anderson was connected. There seemed to be two parts to that. So I wonder if you could start by talking a bit about the waste management case.
Well, waste management was just the grossest type of accounting fraud. I mean, the thing that sticks in my head is that with respect to their dumpsters, and one of the ways they boosted their numbers was with respect to their depreciating assets. They all became more valuable the more they used them, the more valuable they became, so that the the scrap value became much greater for a beat-up dumpster or for a truck that was, had gone 200,000 miles and was falling apart on the street, that they kept every year that the terminal value of the became more valuable every time. The more they used it, the more valuable it became. There were a lot of other frauds that took place at Waste Management too, but that's the one that just struck me as the grossest one, and one that should have been so easy for the accountants to catch. And in fact, the accountants, to their shame, the accountants did catch on to it eventually, but instead of doing what accountants were required to do, which was at the time to say, to stop it, to require a restatement or to resign, the people at Anderson, including people in the national office, came to an agreement with the firm about how the firm would come into compliance with GAAP over a period of years. Unheard of. We're not going to, in other words, Anderson agreed to provide false opinions, not only for the year in which they discovered it, but over future years until at some date in the future, and I forget what the end date was, Waste Management would be in compliance with GAAP. We call it the joke about they were going to do creeping compliance. So that led to not just the auditing partner or the on the case, but this involved the national office and the people in the national office who were basically the real guardians for GAAP. They're the technical experts, and it just shocked everybody, and that's what led to the conclusion that this isn't a case of one or two auditors who are off the reservation, but you're dealing with a firm that has a bad corporate culture, that people at
the firm being Anderson.
The firm being Anderson. Here were gatekeepers who didn't mind the gate. And when they found the gate open, didn't close it. And that's why we decided that the only appropriate remedy was going to be to charge the firm. And the settlement discussions lasted forever. And eventually, we had a couple of false starts. We put Kevin O'Rourke, who was our bulldog trial lawyer who's been assigned to the case. I think several times we pulled him back from the airport on his way to Chicago to file the case. And eventually we settled the case. And the sad case about the Anderson case wasn't that they didn't learn the lesson from it, because after that, they had the Enron case. Again, something that, you saw how that played out.
Yes, I think everyone did. So I think you've answered this question some already, but there must have been other cases where you had to weigh accounting fraud cases. To what extent do we hold the individual accountants responsible? To what extent do we hold the firm responsible? Sort of how did you wind up, what would lead you, what questions would you ask when you were trying to decide a matter like that?
Well, the model that was in place, mostly, was that if it was just the audit team that were involved in it, the appropriate remedy was just to sue them, and not to, even though, respond to a superior, that you could have brought the cases against the firm, but the belief was that it was not desirable to do so. The decision to sue Anderson, the firm, that wasn't ultimately my decision. That was the director's decision.
Sure.
Or it required at least his approval. And it wouldn't surprise me at all. If he hadn't discussed it with the chairman before bringing that case. Again, because of the importance there's a tension there because these are important people for the market, and you need to use judgment in what you do in that area, particularly because there's so few of them. So that was the model, but the model was also that if the firm itself, if people in the home office were involved in it, the default position would be that the firm itself was going to have to take some consequences too. And as the cases go by, I think if you look really carefully at all the cases that have taken place over time, you probably can't perfectly fit each one into a box, at least from the outside, because and they're all settled. In every settlement, there are things that went on in the settlement negotiations and trade-offs that aren't visible outside the people who are involved in it. But I think that's probably still the model.
So I assume there was some intention, or correct me if I'm wrong, that there was some intention to send a message to the accounting profession as a whole through these prosecutions, not prosecutions, through the settlements and litigation.
I think that it was a cannon across the bow of the firms themselves that they needed to pay more attention to what they were doing, to what their auditor partners were doing, and that allowing the home office to be involved in an ongoing fraud is just completely unacceptable. I mean, there's no excuse that they could ever have made that would have convinced me, my staff, the director, the commission, that this is something that it's best to apply our prosecutorial discretion and not go against the firm.
Do you think it was successful in that sense?
Not for Anderson.
Well, yes, not for...
I think so. Although there were a lot of terrible frauds that took place after that, where the auditor should have caught them. Mm-hmm. I think that the creation of the peekaboo,
yes,
they hate that term.
PCAOB.
PCAOB. In polite company, has had a bigger effect. The fact that their audits are being audited, I think, and the creation of their auditing standards have been very successful.
Okay. So you mentioned, I think those are some of the major cases that occurred under your, while you were serving as associate director. You also mentioned the Ahold case.
What was another Ahold? It's another big accounting case. Well, that takes us into our conversation about penalties for public companies.
Maybe we can talk about Ahold and then lead into that.
After we got the Remedies Act, we tried to consider, the staff gave mindful attention to what to do with that remedy with respect to public companies, where ultimately the injury is going to be to the investors, whether they were the investors who were originally defrauded or whether there'd been a turnover, but basically it was punishing the victims. And the view was, including led by the director at the time, and the consensus that the senior management agreed to, that unless the firm profited from the accounting errors, that it was not appropriate to impose a penalty on the firm, with an exception. And the exception being if the firm didn't cooperate fully with the investigation and take the appropriate, what the staff believed to be the appropriate remedial steps to cure the problem, then a penalty would be in order. You weren't being penalized for the accounting error, you were being penalized for what you did after what you did. And that line held pretty well.
And as I understand it, you had conversations in the division about what was appropriate.
We had a meeting with the senior enforcement staff in one of the conference rooms with the director presiding, and we discussed the issue of how to deal with these things. And that was the conclusion we reached. And the first, I think the first big penalty cases, big at the time, more than $1 million, were either the Lucent or the Xerox case. And again, it was, and I believe that the litigation release or the press release that went with them mentioned or didn't mention cooperation, or it may even have mentioned a lack of cooperation, and that's why the penalty was being imposed. Well, that didn't hold, and the pressure was that what are you doing to the firm? They did this terrible stuff. Why aren't you punishing them more? And losing sight of the fact, well, who's really being punished? And so eventually it grew and got, in my view, completely out of control. And so that, for example, by the time I left in the Shell case, the huge penalty, at the time was a huge penalty, might have been more than $100 million. I still, and the director agreed with me that in the Ahold case, we got the cooperate. They turned themselves inside out. They got rid of all the people and did everything we asked them to do in the course of the investigation. And we commissioned them to do a lot of work. And we're satisfied with the work they did for us.
What did you ask them to do?
Well, they waived the attorney-client privilege. We got all they conducted an internal investigation. We basically got the whole investigation. When we wanted them to go out and look at something else, they went out and looked at something else and they came back with it. Sometimes there was something there, sometimes there wasn't. This was in the fairly early days of basically deputizing the company. There were other examples that preceded that. We didn't invent that model, it was in place, but we exploited it to the hilt. And they did their part too. And as a result, we decided, my assistant director and I, we decided this is a good example to make the point that there really is a benefit for cooperation, and we didn't put a penalty on them. And somebody, one of my friends, called me after I said who'd paid a penalty. He called me and he said, what are you doing? My client paid all this money here, and the people in this case didn't pay anything. How am I going to explain it to them? And I said, explain to them by the cooperation that they got, and that was the end of that conversation. But it was an interesting phone call to get.
Did you find subsequently that companies sort of got the message? They knew cooperation was going to buy them, well, not buy them, but cooperation was going to
well, they did it about shortly. I think before the Ahold case, the Seaboard order came.
Yes.
Where the commission set forth the factors that it would consider in imposing penalties on public companies. And that was carried on again later in the early 2000s. I think it was in the early 2000s, where maybe later than that, where Kazami gave a speech where it said basically, here are the factors we look at in imposing penalties in these cases. But they haven't really been. The evidence of honoring those standards is not clear to these people. I'm on the outside, not clear to me. I think that the criticism from the Hill and from the press about not imposing fines on public companies is very hard to resist. I mean, there are arguments. There are arguments that can be made for penalties on public companies for violations. After all, it is the entity. But if you look past the entity and see what it really is, I'm subscribed to the Seaboard order.
So bringing up remedies is interesting because you did see an extraordinary, during your tenure, and I guess immediately before, an extraordinary series of steps which gave the SEC a great many more tools than it possessed, frankly, during most of its history. There was the 1984 Insider Trading Act, the Remedies Act in 1990, Sarbanes-Oxley. And I think you've already covered this a little, but I guess my first question would be, what when you actually joined the staff, what remedies did you have at hand? What tools did you have to?
The remedy was for regulated entities. There was an administrative proceeding process where you could bar somebody from the industry, a very powerful tool. With respect to public companies, there was a statutory injunction of obey the so-called obey the law injunctions, and disgorgement. In some cases, by the time I arrived there, outside of insider trading cases, disgorgement was sometimes sought and sometimes not. It wasn't as consistently sought as it developed. It developed into a standard tool in every case where there was a benefit that the defendant obtained. But in the obey the law injunction, the real remedy was for public companies wasn't being enjoined to obey the law. They had to obey the law anyway. The threat of contempt contempt for violating it, the commission never brought those because you had to do the same thing to bring a contempt case that you'd have to bring the new case from the start. So there was no reason doing that. So that the real tool was, of course, the reputational harm to the firm, which firms took very seriously. I mean, if you're in the market, having a reputation for violating the securities laws is not good for you in the market.
Did you find that as you got more tools to sort of deploy against companies or individuals, that it actually changed their behavior, or did it change the way you approached your work in enforcement?
If it's changed the behavior, it's in a way that's too small to measure. The samples are too small. It's too small to measure. I mean, people who, particularly in public company, it's individuals who commit the violations. The fact that they may face a penalty as well as a disgorgement or an injunction. I don't know the extent to which they factor. I don't think people don't think about what's going to happen to me if I'm caught. I think my view is they think they're not going to get caught, or they manage to convince themselves of their own good faith that there's nothing seriously wrong with what I'm doing. It's sort of like being over time at a meter. I think that the existence of penalties probably has not had a large impact on people's misbehavior. Okay. Sending people to jail, I think, probably does. But again, I don't think the people who are going to jail ever thought they would. Yeah, in the area we're talking about.
Yes.
If you're a drug dealer, it's just part of your cost of business to go to jail.
Sure. So towards later on in your tenure, in the end of 2001, 2002, there were obviously an extraordinary series of cases, starting with Enron, followed by WorldCom, followed by we could right. spell out the cases. And I'm curious why. I want to ask about sort of your response to those, or how the enforcement responded to those in a second. But to begin with, how would you explain why suddenly a bunch of extremely large and until then prominent firms found themselves in such basic trouble?
I think it's driven by individuals. It either, depending on which example you're looking at, either by fiddling with the numbers with top-end adjustments, or putting excessive pressure on people below them to make their numbers, you've got a company with a lot of different divisions, and you put more pressure on them than they can bear, because they want to keep their jobs. So they, either get out of the gray, convince themselves. Some people convince themselves it's in a gray area. Some people recognize they're out of the gray area and the black area, but between a choice of getting fired or worrying about someday being discovered, I'll deal with the short term and not worry about the long term. So I think it's those types of pressures that, maintain your stock price, beat your numbers, that not get caught. I'm not going to get caught.
Did the eruption of those cases change? It seems like there was so much occurred in such a short period of time. Did that put any pressure on the division? How did you choose which cases to pursue? How did you deal with the resources you had?
Well, I think the staff ended up pursuing all the big cases. I mean, they were all big enough. Nobody was going to let WorldCom go away. And in fact, Chairman Pitt at the time, took the extraordinary step of, in an accounting case, to have us run into court and get a temporary restraining order, preliminary injunction against the firm. Nobody was going to leave cases like that unaddressed by the commission. That's their core competency.
Sure. If we could turn a little, I'd like to talk about some of the people you worked with. And perhaps a good place to start is with the different directors of enforcement, if I could ask about them. So I know you were actually hired by Gary Lynch, and he was there several years before he left. You overlapped for a number of years. So what was your relationship with him and your perception of him as a director?
We worked together very closely. I mean, it was I'm not sure I had all that much contact with him in the first few months I was there. I was trying to get my feet on the ground and get on top of the things I was doing. But with the start of the Levine case, from that point on, I worked with him very closely right through his departure. And he was a terrific guy to work for. All the people I worked for are really wonderful people to work for. Collaborative, quite different personalities, but all very collaborative, very supportive of the staff. At the same time, had a critical eye, doing what they should be doing, which is to keep you from making mistakes, cases for one reason or another that were too risky. Even though there may be cases, there may have been a case there that one of the things that's important in a government program where resources are so scarce is you want to win most of the ones you bring, so that people recognize that if you want to litigate, you litigate against the case that the defendant's going to lose, or they raise issues that might be better addressed through a regulatory avenue rather than through a litigation area. There's a criticism of the SEC is they make a lot of law through litigation.
Yes.
I think a lot of it is done through litigation. I think it's particularly not so much in the public company area, but more in the regulated industry area. So that there was certainly all the directors were appropriately not afraid of cases, but they're never afraid of a case.
Yes.
But a case might not be the right case to bring. And the sense to treat people fairly. I think that when I was there, that was, the idea. I think whether it was Bill or Gary, I first heard it from, it'd be tough but fair.
What about Bill McLucas as a director?
Oh, he's just a great guy to work with. I mean, he was a guy very smart, very hardworking, very protective of the institution, in a good way, but a very easy guy to. Not that he always agreed, but he's an easy guy to have a beer with.
And then he was succeeded by Dick Walker.
By Dick. You know, he knew the stuff too. He'd been the director in New York and had seen all the moving pieces. And again, he was, you know, a different guy, a little more reserved. But again, easy. I found them all easy to deal with. They're just easy to deal with. It's just a bunch of people with a common goal, and all concerned about protecting investors, protecting the market.
Did they come in? I want to finish up with Steve Cutler, but did they come in with different? Did you have a sense that when there was a change between directors, things changed in the division, a different set of priorities, and not radically different priorities, but perhaps different emphases?
Well, the emphases are really driven less by the director than by the chairman and the commission.
Okay.
And I think Dick came to the Home Office as the deputy director straight from defense lawyer. He was a really good defense lawyer. I think if you asked him, is he coming up? Oh, he's on the.
He's already been in.
He's already been in. I'd be
Yes.
interested what he said about that, because at some point after he'd been there for a while, he decided that the preconceptions he came there as a defense lawyer turned out largely to be wrong, and that the people we were pursuing, we were doing the right thing, chasing after them. He said something to that effect. He was a very quick. It didn't take him long to figure it out. I mean, he was a very quick learner, very, very smart guy. Again, easy to work with.
What about the chairs then? Because you just said that the chairs were the ones who were. We've already talked a little about Levitt, and you said the chairs would also be setting the tone. And I guess you worked under a series of them as well. I should start by asking, to what degree did you actually interact with the chairs and with the other commissioners?
It varied. At one, you know, depending on the times I dealt with the commissioners, was either when a case was pretty ripe, and if I had things I needed to discuss with them before the case was recorded to the table, you know, was presented before the commission, I'd go. If they'd either call me or one of their legal assistants would call me and ask questions, I'd go up and see them. Or if were having concern, if I was being told that, you know, a commissioner has a concern about this case or that case, you know, I'd go up and, you know, we'd have it out. Always the culture in the building was really, when I was there, was you could disagree, but it was always mutually respectful and collegial. And people disagree about things. Sometimes I'd prevail, sometimes they'd prevail, sometimes they'd raise something that I hadn't thought about that could cause reflection. Sometimes, you know, the things that come to mind most vividly with the last individual defendant in the case, you know, whether that person really belongs in the case, whether it's fair to have that person in the case, and, you know, sometimes we take it out.
Were any of the commissioners particularly memorable, or you had particularly interesting interactions with? I want to talk about the chairs in a second.
The most challenging person to deal with was Commissioner Atkins, who was very smart, and he read he personally read the action memos. He had a more jaundiced eye about whether a case should be charged as harshly as it was, or should be charged at all. So that the discussion with him was always challenging. to go back to my beginning,
Yes.
when I spent my first year, I went to law school as a lark, and I loved it. What I loved about it was the 1L thing, which I think probably doesn't exist anymore. A discussion with Commissioner Atkins was like that. It was an intellectual discussion about the case that, I may have convinced him, he may have convinced me, we may have gone our separate ways. I usually had the votes. But nonetheless, it made it really it's the kind of thing that's what lawyers do. They argue the law, they argue the facts, so that he more than any other commissioner in my time there wanted to do that. And so I liked that. I might not have agreed with him all the time, but I liked it. Commissioner Fleischman really fell into the same category. He knew more securities law than 99% of the people at the SEC, and he really was a scholar on the subject. And he again was concerned about over prosecution, so it was always a challenge and rewarding to deal with him, because you could do what lawyers do. It's what I like to do. I like to do what lawyers do. Joe Grunfest was in it. He also had you could have really deep intellectual, what I think of, at least deep for me, discussions about the facts and the law in the case. And so he was always often eager to be willing to have a conversation with the staff about things instead of just making up his mind and deciding what he was going to do. And those really stick with me. And Chairman Pitt was the same way.
Mm-hmm.
You'd walk into his office anytime and discuss a problem in a particular case. And
were you able to do that with, say, Chair Levitt or Chair Donaldson in the same way?
Levitt and Donaldson were more a corporate model in their offices, that you'd make an appointment ahead of time. You didn't just, at least I didn't, the director may have been able to walk in, but I couldn't just walk in. I'd be told by the guardians, make an appointment. But with all the other commissioners while I was there, I could walk in and have a conversation, if necessary.
Okay. So it's natural to pay a fair amount of attention to the people who are chairs and commissioners and directors. What about other lawyers you worked with at the SEC who left a strong impression on you, who ought to be aware of, who perhaps wouldn't have had as much a public profile?
Well, my deputy in the trial unit was Barry Goldsmith, I brought in, and made him my deputy when the slot opened up. He's had a fabulous career since then. He went on to FINRA as the chief enforcement person, or NASD at the time, NASDAQ, NASD, and he sticks in my mind. Chris Mixter, who was, I think, Barry's successor as the chief trial unit again. I was always wanted when I was the associate director, I always wanted his input on difficult cases about the cases. I'm going to leave out a lot of people who should be in this catalog, but Jim Koff, my assistant directors, all were just superb, and Jim Kaufman, Jerry Eisenberg, Eric Schwartz, Rick Sauer. I mean, I was blessed with hard-charging associate directors, but who at the same time, would be a little bit to keep their staff from getting carried away. I told when I was an associate director, brought in a new staffer. I told him, I'll never criticize you for being too aggressive. It's your supervisor's job to do that. And they all were appropriately aggressive and recognized good cases when they saw them, and of equally or greater importance, since you don't want to bring cases unfairly, we're careful not to bring cases that you shouldn't bring.
So in 2004, you left and came to, I believe, straight to Jenner and Block as a partner. Am I right about that?
Right.
What led you to leave the SEC?
I'd been there a long time. My plan was to go there for 3 to 5 years to get retooled and then move on and do something else. I loved it so much, I didn't want to leave. But after 19 years, I thought, this is getting too comfortable. I like challenges. The cases were challenging, but at the same time, it was time to move on. Jerry Solovey, who at the time was the chairman of the firm, said, "Why don't you come here?" I said, "I'm happy here. I'm not interested." He said, "Well, you ought to think about leaving." So I decided, okay, I'll look around and see what there is. And I did some interviewing, got some offers. Jerry was the most persuasive, and one of the things, in addition to being a fantastically persuasive person, he also kept reminding me that it'd be my place to run, and that in addition to that, we don't have a mandatory retirement age. I expect you to stay here. I think I can't force you to stay, but I hope you're going to stay to 3 to 5 years. But he said at many of the places you're talking to and some of the offers you have, either they have mandatory retirement ages or they have deals where after you reach a certain age, you have to, as he described it, go beg somebody to let you stay. And I didn't like that idea so much. I had a lot of energy then. I still think I have a lot of energy. I like what I'm doing, and so that's why I ended up here. The 3 to 5 years have turned out to be 14, coming on to 15. It's been a good gig.
So, looking back at your 19 years at the SEC, what changed the most during your time between '85 and '04?
It became, well, it was a tiny place when I was there. As I mentioned, there were 8 or 9 people in the trial unit. I think the whole enforcement division, 160 or 170 people. It was very tight. We all knew each other. There was a great esprit and a sense of being the best of the best in the government. I think that it's grown huge since the enforcement division must be 5 or 6 times the size it was then. So that inevitably there's a cost that goes with that. People who are there will complain about the bureaucratization. Some of it may be an excuse to why they have to do what they're doing. Some of it, I think, is they do feel that it's harder to get anything for the staff to get anything done because of the bureaucracy. I think so that's one of the things. I think that's the downside in the growth of the place. I think that there's been some upside too. I think that the creation of the special units has been a good idea for the market and for investors. I'm not so sure it's so great for the staffers working in there because they get exposed to only a single area of the law, and particularly if you want to leave, being able to having an understanding of not just how an insider trading case is put together, but how an accounting case is put together, a disclosure case is put together, or a pump and dump case is put together. Well, we don't have them in private practice, at least in big law firms. Mm-hmm. But to get broader exposure, I think that's lost to some extent for the people in the specialized divisions. But I think in terms of getting the job done, I think it's been a plus. I think one of the things that was done back in, I think it was when Joan McCown, another person who deserves mention, put together the enforcement manual.
Yes.
So that everybody still doesn't follow the same hymn book, but they're closer to it. And it also, I mean, to some extent, it devalued the value of people who'd been there. Didn't completely devalue it, but it did to let people who didn't work there know how the system works, what the process is. I think that was a great innovation. I think that the development, I don't know what's in their black boxes, but they do have black boxes now, and they seem to be developing. Again, you can't tell on the outside how many good cases they're really developing out of the boxes, out of their black box. But I think that it's using.
This is the high-tech surveillance.
The high-tech surveillance. I think that's a good innovation. It probably would have happened. I think it had to happen inevitably, but I think they've, instead of doing it reluctantly, I think they've done the appearances that people I talk to, it's been a welcome tool. I think that trying to be more proactive rather than reactive, looking at what the academics are writing has helped, although I'm told that a lot of the work they do on the stuff that shows up in journals of economics turn out not to pan, that the majority of them don't pan out, but they're anomalies in the markets that they should be looking at.
So you mentioned a little while ago that Dick Walker, when he joined, and we will perhaps get his view on this as well, changed his mind after having been on the defense side and then coming to the SEC. I don't know, I won't ask if you've changed your mind, but now that you've been on the other side for 15 years, has that given you a different perspective about the work of the staff and about your time at the SEC?
Well, the change is really sort of started when I was at the Commission. The deputizing companies to investigate themselves, that's a burden and a blessing to us on private practice. I think that I had people would tell me how much it cost when I was at the SEC. Not my problem. Now it is my problem, and I think that it was probably true when I was there, and it's true now, at least. Often the default position with respect to, the big cost is document production. Witness preparation is a much smaller part of what we do. That the default reaction is, well, we want everything we listed in our attachment to the subpoena, and concern about that they're going to miss something if they. I think that it's harder than I expected to negotiate document production with the staff. Some people have the confidence to, or are more open to the idea of, finding ways to get them what they wanted without burning down the barn to find the pin that may or may not be under the haystack. It varies. That's the hardest. That's one of the harder things I found is to deal with, is just managing the cost of an investigation. In terms of, they've gone away in a bunch of cases I've done that I understand why they opened them. They opened them for good reason. It just turned out not to be. It wasn't what they thought it was. I've settled a lot of cases, and they're settlements.
All right. Thank you so much. Before we finish up, is there something else? Are there questions I should have asked you that I didn't? Are there issues that we should cover that you'd like to talk about?
I think we did it. I think our prior discussions, I think we managed to hit everything. You asked me everything I wanted to talk about. I hope I talked about everything you want to talk about.
I'm going to say thank you so much for your time, and we deeply appreciate it.
This has been great fun. Thank you so much, Harwell.